Very good evening, my dear friends. Today we are going to discuss about prospectus. Last session I told you about collection of share capital by way of share capital and loan capital. Both come as capital of the company. I have explained in detail. Then the person who is responsible for this collection and then bringing the corporate entity into existence, he is called promoter. Promoter. Then I have already explained about the promoter. You will be able to definitely write a 20 marks question without any hesitation. So I have given enough explanation in that regard, my dear friends. Then, how this promoter collects the capital, what is the process? What are the legal provisions and the judicial interpretations? These are all the things we are supposed to study further. That is under the caption of the subject prospectus. In fact, friends, a private company cannot invite the members of public to subscribe to its shares or debentures or even public fixed deposits. Then it has to go for only private placement. Whereas a public limited company can gather the share capital or loan capital either by way of private placement or by public issues. Share capital could be preference shares and then equity shares. Loan capital could be long-term loans, short-term loans from the banks, and then debentures, bonds, fixed deposits, and they can invite the public. What is most important is that they can give invitation to the public to contribute. Then, this invitation to public is strictly prohibited for private limited companies. It is permissible for the public limited companies. That is the distinction. Going by this, my dear friends, you find that this particular collection of money through public is to be by way of a document to be released to the public called prospectus. That is where the whole subject of prospectus comes into picture. To tell you in general, the public limited companies invite the public to contribute to its share capital or loan capital by way of prospectus being issued to the public. It is a document stipulated under the Companies Act as well as the SEBI regulations, SEBI Act, wherein the document contains various necessary details as they are supposed to be stated thereon as prescribed. What are the legislations here cover this particular subject matter? The Companies Act 2013, the Securities and Exchange Board of India Act, the Securities Contracts Regulation Act, the Depositories Act. These are all the legislations which deal with the subject, and any foreign investment comes into picture. The FDI rules and then the FEMA rules also. The FEMA enactment as well as the rules thereon. So this is how this particular subject come into picture. So the regulators happen to be the Ministry of Corporate Affairs, the SEBI, the Reserve Bank of India. Then dispute resolution is concerned. The dispute resolution forum is the National Company Law Tribunal. So friends, basically sections 23 to 42 cover this particular aspect of prospectus. What is a prospectus and then how it has to be issued to the public? What are the pros and cons, permutations and combinations? And then how do we go about this particular aspect? These are all the legal provisions. And come to the definition part. In fact, a clear-cut definition you find under section 2 subsection 70 of the Companies Act 2013, where the prospectus is defined as any document described or issued as a prospectus, and it includes a red herring prospectus referred to in section 32 or shelf prospectus referred to under section 31, or any notice, circular, advertisement or document or other document inviting offers from the public for the subscription or purchase of any securities of a body corporate come under this definition of prospectus. What is the significance of this particular definition? Prospectus could be even a circular, a small piece of paper, but it contains an invitation to the public. Then it should contain the necessary guidelines, necessary regulation. It should contain the details as per the necessary guidelines and regulations given under the Companies Act, read with the Securities Exchange Board of India Act, and then other details thereon. This is the most important aspect. If those details are not given, then the parties are liable for prosecution. And further, it's a case of a prospectus being treated. I have circulated, for example, as promoter, a small piece of paper, and that is tomorrow considered by the court as prospectus, and then it contains a misstatement, then that is the end of my career. I would be put on civil and criminal liability, including imprisonment. The reason being, in fact, no misstatement is permissible in the prospectus. You cannot say it is a circular. There is a reason why whatever details are given in the newspapers for public issues, you find this is not a prospectus, a heading. This is only an intimation. They take care and put a safety valve into that. This is the most important aspect, my dear friends. So prospectus is the means through which the capital is procured for the public limited company through public contribution by giving an invitation to the public. This is the most important aspect of prospectus. In that event, prima facie, what you have to find is that what is the concept of prospectus? What amounts to prospectus? What does not amount to a prospectus? We will divide our study into 3 segments. We will be very clear on the division of our subject matter so that it is easy for you to remember also. This is one way of studying the subject. You have to divide the subject into segments, and then each segment will tell you as to what it contains and then the information thereon. With that particular background, you will understand the subject better and then you will learn it better. So, my dear friends, the first segment is concept. What is the concept of prospectus? What does it mean? Why should we issue a prospectus to the public under the provisions of the Companies Act? Second one, the legal provisions thereon. What are the legal provisions? The various legal provisions covering multifarious subjects relating to prospectus. The third one, the civil and criminal liability in making a misstatement of a prospectus. If the statement is proved to be a misstatement, whoever that person is, he would be put on prosecution and ultimately he would be liable for appropriate punishment also if the guilt is proved. I will give a small example. In a particular case earlier where fisheries was in the boom in India, one senior official of UN came back to India. He is an Indian. And then he at that point of time, not a shareholder, not a debenture holder, not a fixed deposit holder. He, in his capacity as an expert, became a director of the company. And then, in fact, he has made certain statements. Unfortunately, the boom came down by the time he left for US, and then the entire company collapsed. Some of the shareholders said there was a misstatement. Now the matter has to be examined. At the age of 80, when he came back to India, he was issued summons by the Register of Companies. Then an explanation was given. I handled this matter. Then finally Registrar said, sorry, let the court decide. And he has put the matter before the Court of Economic Offences for prosecution. You understand? This is the impact of misstatement being, in fact, alleged, and then it is put on a trial in the Court of Economic Offences. You understand the dimension of the problem. So, friends, in fact, a person could be very comfortable as a shareholder, but it's a very difficult job today, a person becoming a director, because he has to get it in. Apart from that is liability. Apart from that, the responsibility follows the liability. These are all the practical things one has to understand with regard to a person becoming a director of the company. So, first segment concept, second segment the legal provisions, the third segment the doctrine of golden rule of legacy, that is misstatement in the prospectus. These are all the three segments we have to study in this subject of prospectus. So today I will cover the conceptual study. Concept means that the prospectus is basically a particular document issued covering the relevant details, as I have already explained, under section 2, subsection 17, and it includes any scrap of paper, a notice, a circular, any advertisement, if it contains a simple invitation to the public, right, to contribute to the share capital or loan capital of the company which is under public issue. This is the most important aspect. In the earlier times, there was a statement in lieu of prospectus. Now it is dispensed with. The law has been changed. You have to update yourself with the latest Companies Amendment Act 2019, read with the proposed 2020 bill, which could become a law by an ordinance or otherwise at any time, any point of time. So friends, now I cover the concept. I will come to the legal provisions tomorrow. Then the rule of golden legacy either tomorrow or after tomorrow. This is how we will plan up our discussion now on this subject of prospectus. Friends, the most important English citation on prospectus is Nash versus Linde. N-A-S-H, Nash versus Linde, L-Y-N-D-E, 1929. I told you Seale's Companies Act, you find out, company cases, you get all these cases. Some of these cases are available in internet for your benefit. Solomon versus Solomon case, Lee versus Lee Air Forming, I have ultimately secured and I got them downloaded from internet. At an appropriate time, I will circulate them to you, the original text, right? So that would be of great help to you to understand. You can go through, and tomorrow a question comes, Solomon's case, you will be able to answer very well, because the entire citation, entire case text, I am going to send it to you, my dear friends. Then friends, this is Nash versus Linde, where the English court held that unless it is an invitation, that particular piece of document is not a prospectus. And if it satisfies the condition of invitation, even it is issued to a definite class of public, but not all, still it is considered as a prospectus. If it is considered as a prospectus, you have to give the promoters have to give, the directors have to give the necessary details, and if the details are not given, they are liable for punishment. If the details are false, they are liable for punishment. If details are incomplete, they would be charged for fraud unless they prove their innocence. This is the danger involved. That's the reason why one has to be extremely careful in issuing this document called prospectus. Nash versus Linde. I will take you to the next important case. This is very interesting. South of England, Natural Gas and Petroleum Company Limited. South of England, Natural Gas and Petroleum Company Limited, 1911, where the prospectus contained a marking for private circulation only. It contained a marking for private circulation only, but it was not publicly advertised and it was circulated to only a certain class of persons, and then it contained an invitation to public. It contained an invitation to public issued to a certain class of persons. Now the question, is it a prospectus or not? Since it contains a public offer, the court said it is a prospectus. It has to be viewed as prospectus and examine whether the necessary contents are there or not. You understand? So in the same way, here, as I told you, sections, in fact, I have already told you, 23 to 43 contain the various details pertaining to this particular prospectus, wherein conceptually I am at the moment telling you about what is prospectus and then what are the contents thereon and what is the significance of that. Now friends, another important judgment of Chancery Division, Government Stock and Other Securities Investment Company Limited versus Christopher, 1956, Chancery Division, very old case. Here, please carefully listen. An offer was made by a company inclined to purchase all the shares in two existing companies and in consideration to issue its own shares. That means two existing companies are there. It wants to acquire their shares, and for their shares, it is offering its own shares. A circular was issued. Is it a prospectus? Now a question, this kind of offer, whether could be taken as an offer made to public or not. Actually, it is not issued to public. It is taking of existing shares and offering my shares to you. So it is not public issue. It is amalgamation. It arrangement. For that reason, it is not a prospectus. So you understand the subtlety of law here. So the court held that it is not a prospectus. This is the logical way. Nash versus Linde, natural gas case, and then this government stock case are the three very important citations. You give in the examination, certainly, dear friends, you will get very good marks. So here, another important question, what is the meaning of the word public? The word public used while referring to prospectus means the persons in general and then members of public, and includes a reference offering shares or debentures to any section of the public. Whether the public is selected members or debenture holders of the company concerned or clients of the persons issuing prospectus or in any other manner, it is immaterial. So, even the circular is issued to a particular section of the members of public exclusively, but it contains an invitation. It amounts to issuing a prospectus, and the relevant provisions of the law, that is the Companies Act, read with the Securities and Exchange Board of India Act and the regulations thereon, must be complied with, and those details have to be given, failing which penal provisions will follow. So here, an invitation to public also must indicate it is accompanied with some measure of publicity. That is what Nash versus Linde case says. And then, in fact, so basically, prospectus does not create, another important aspect, whether prospectus creates a contract by itself. Now, this is another important aspect we had to see. By issuing a prospectus, whether contract is created. Prima facie, in fact, if the particular prospectus induces the contract, and then in the event the particular stipulations say that Stipulations say that the conditions found in fact amount to making a contract, then you can say the prospectus has created a contract by itself. Otherwise, in fact, a prospectus does not per se create any kind of contract. Now, friends, the Securities and Exchange Board of India Act contains now several provisions pertaining to different kinds of prospectus and the different, in fact, rule. I mean, the details supposed to be given, the various reports supposed to be given, the experts' reports, and so on and so forth. Now, these are all the permutations and combinations. And then further, it also deals with the minimum subscription which is supposed to be procured thereon. In this particular regard, what I draw to your attention is that, in fact, conceptually, what we have understood about prospectus today is that prospectus is a document which is, in fact, containing an invitation to the public to subscribe to its share capital or loan capital. It should contain the necessary details as envisaged under the SEBI, and you must find out that these particular public issues are covered under the provisions of the Companies Act, the SEBI Act, the SECRA, and the Depositories Act. Apart from that, foreign investment, the appropriate rules and regulations of Reserve Bank of India. This is the law. Conceptually, it is a document which should contain necessary details, failing which it will attract penal provisions. If it is not properly given, it will attract penal provisions. If it is not given, it will attract penal provisions. If there is a misstatement, fraud, misleading statement, then also it will contain appropriate rules and regulations. I mean, provisions where this particular subject matter would entail punishment thereon. So conceptually, it is a very important document and it should contain all the necessary details thereon. The details you will find in the SEBI regulations thereon. So now conceptual study is over. Now the second part of our discussion would be, tomorrow we are going to deal with, that is pertaining to the legal provisions. All the legal provisions I will explain in tomorrow's session. It will be a lengthy session tomorrow. You must have enough patience to sit, because several legal provisions I had to bring to your notice, and in the examination you can't expect 16, 17 out of 20 unless all the legal provisions you quote, the gist at least you quote. Naturally you can't give in verbatim, but the gist, any interpretation is required of the courts of law, the interpretation also will be given thereon. Then the last segment, maybe day after tomorrow, we will see, that is pertaining to the misstatement and the consequences thereon. So with this particular background, we will complete our discussion on the prospectus. So friends, we will proceed further, and thanks for your patient hearing today. We will be in touch again. Fine then, good night, goodbye. Thank you. Bye.